coming to a culmination yesterday, the Joshlin Smith trial. Well, it came to an end on Friday with presiding Judge Nathan Erasmus finding the missing girl's mother, Kelly Smith, and her two co-accused, Jacquen Appollis and Steveno van Rhyn, guilty of kidnapping and human trafficking. After nearly 3 months of court proceedings, Erasmus handed down his judgment in the Western Cape Division of the High Court, which was sitting at the White City Multiple Purpose Center in Saldanha. So let's get you some reaction and analysis from legal expert Dr. Bongani Nkosi. Dr. Nkosi, good afternoon, and thank you for joining us. So let's start with the verdict itself. Did it come as a surprise to you, given what had transpired in the build-up, the state's case going unanswered by way of evidence or testimony by the accused?
Thank you, Thulasizwe, and good afternoon to the viewers. This case, to me, didn't come much as a surprise. I was expecting that indeed the three will be convicted of the kidnapping as well as the trading or trafficking in humans. Thulasizwe, we ought to be aware that South Africa was actually expecting that justice will be served in this particular case, much so that some months ago we had the acquittal of Pastor Omutoso. So I would say this case vindicates justice. Justice has actually been done. We still await for the judge at a later stage to pass his sentence, because he had already found them, the three, guilty.
Yeah. I mean, Dr. Nkosi, I must say that at the point at which the accused closed their case without either themselves testifying or calling any other witnesses, I was puzzled a bit. Tell me about how that works. I mean, yesterday, in summing up, Judge Nathan Erasmus talking about the state calling 35 witnesses, 42 documentary exhibits, and including an inspection in loco, and 5 physical exhibits. Can an accused afford to not answer once such evidence has been placed before a court if they've pleaded not guilty?
Yes, Thulasizwe, procedurally, an accused person in a criminal proceeding has a right. They may decide not to testify, to take the stand, to give their version of event. However, that decision, when it is made, it has to be made with caution, because if the court is of the view that the case made by the state is such that it can convict, definitely it will do so, as we have seen with Judge Nathan Erasmus, convicting them without them having testified. It is possible, yes.
Yeah, and I suppose I ask this question in the context of, at the close of the state's case, at least 2 of the 3 accused had brought an application for an acquittal at the close of the state's case. So isn't that an indication that when the judge refuses to grant that application, that as a defense you should mount some kind of a defense and not leave it to the judge to say, do with me what you will?
At that stage, when the state has closed its case, an accused person may make an application for discharge in terms of Section 174. However, the court will have a discretion whether to grant or to refuse. If the court is of the view that there is a finger pointing at the accused person, definitely it will refuse that application. This is what exactly happened in this case. I would assume they were simply taking their chances.
So let's talk a bit about the crimes that are involved. There's kidnapping and there's human trafficking. The human trafficking one is quite interesting in that it was only recently, recently 2013, codified in terms of that act, the Combating of Trafficking in Persons Act. Just how difficult is it to prove that particular case?
Yes, Thulasizwe, the state had a bit of difficulty, but at least we are happy, we are pleased that it managed to prove its case in the manner it had because the accused person opted not to testify. Proving that somebody has been trafficked is quite difficult, and this is what we have seen in this particular case. As I speak now, the body of Joshlin has never been recovered, so we do not know if she's still alive or not. But then we applaud the state for having given a fight to say, we're not going to let this case go. Let it not become one of the statistics where an accused or accused people simply go scot-free.
Yeah. And,
It's the,
and among the other issues that we were dealing with was the issue of kidnapping. And that has a long tradition in the law. And I suppose if you look at other cases, that's, I would imagine, by comparison with human trafficking, would I be correct in assuming that the law is pretty settled there and the state probably had an easier time knowing what exactly they needed to prove?
yes, the law is settled in that regard. After the coming into operation of the Combating and Prevention Act you referred to of 2013, at least now there's some framework within which to prosecute offenders. It was unlike in the past where we had to rely much on the principles of common law or on other statutes to actually prosecute those involved. In this particular case, Tula says, I would assume it was easy for the state to prove that trafficking and the kidnapping because you had the lady by the name of Lombard who eventually became a state witness. So most of the information or the data was forthcoming from her because she exactly knew what transpired when Joshlin actually disappeared.
And then you mentioned a bit earlier on that we have not found the child, Joshlin Smith, either alive or dead. What happens in an instance, where the worst outcome possible happens and perhaps at a future date she's found and her body is found dead? All of us would be hoping that is not the eventuality. But if it does happen, what happens? Would they then be charged again now with murder over and above what they've been convicted with?
Tula says, firstly, I'll make reference to one case. It happened some years ago. Constable Francis Rasuge, is it Collins Nkuna? The viewers will remember that case, where eventually Collins was found guilty, though the body of Constable Rasuge was not found. But in this present scenario, what is likely to happen is that in the event the body of Joshlin is found, let's say, what is likely to happen is that, yes, the state will be within their rights to add another charge, which is that of murder. But then what becomes important is the state proving beyond doubt that Joshlin was actually murdered by the three accused persons. From the way I look at it, what they could have done, yes, they kidnapped her, and they trafficked her to another person or to some other persons. So there's that possibility that the state may find it difficult to prove who caused the death of Joshlin in a future date.
Yeah, because that needs to be proven as an element that this particular accused, through their actions and conduct, caused the death. That's one of the elements, isn't it?
Yes, it becomes difficult because it has to be proved beyond reasonable doubt. It's not on balance of probabilities. Proving beyond doubt is something else.
So let's talk then about some of the evidence that was led. You mentioned Laurentia Lombard. This was the, initially an accused, but who turned state witness. The judge had, a bit of evaluation to do in terms of the evidence that she gave, the credibility thereof, consistency thereof. I want you to talk to me about that, the importance of a person who is an accused turning state witness. Does the state then need to do more over and above that? This is a person who says, I was there, I was involved, that's good enough, we submit it? Or do they need to do more by way of corroborating what this person says and closing the gaps where there are inconsistencies?
Firstly, as I pointed out earlier on, the state has that obligation of proving its case beyond a reasonable doubt, even in a situation where you have one of the accused being converted into a state witnesses. That doesn't take away the onus of proof on the part of the state to actually go all the way in proving that indeed the accused or those accused have actually committed the offense or those offenses. So what we see in this particular case is that the 35 witnesses, the 42 exhibits submitted, what the state was simply trying to show was that we have a strong or a tighter case against the three accused persons. And again, they had an advantage because their case was never disputed because the three accused persons opted not to testify. So now, I don't blame the judge. According to me, he served justice because this case was simply not contested.
And in terms of the statements that are made and confessions that had been made by some of the accused, we saw a situation where it was almost an attempt to recant those statements and argue that they had been procured under duress. That led to that trial within a trial. How common does that happen? How frequently do we see this playing out in courts of law, and also how it was handled in this particular case, the rejection of that attempt to recant?
When an accused person tries to recant a statement made before the police, a trial within a trial has to be conducted. The purpose or objective thereof is simply to establish whether the accused person was coerced, influenced, or otherwise in making the said statement. Should the court find that the accused was coerced or influenced in another way, then obviously whatever statement that was made will then not be part of the evidence. So in this particular case, according to in my considered opinion, the accused persons knew very well they were guilty, and as such, they had to try all means possible to exploit the system to see as whether they can succeed. That is why the public was not surprised that some of them claimed we had been tortured in making these statements. And in that case, the magistrate before whom the statements were made had to be called in when this trial within a trial takes place. And the court has to make a ruling whether the statements become part of the record as evidence or not. In this case, it was ruled there was no torture. The statements were made freely and voluntary.
All right, I've got to thank you for your time and your insights. It's really been insightful, this conversation. We've learned a lot. That's Dr. Bongani Nkosi, who is a specialist in public and criminal law at the University of Limpopo.